Marbury v. Madison.
Marbury v. Madison, 5 U.S. 137, was a landmark United States Supreme Court case in which the court formed the basis for the exercise of judicial review in the United States under Article 3 of the Constitution. The landmark decision helped define the boundary between the constitutionally separate executive and judicial branches of the American form of government. The case resulted from a petition to the Supreme Court by William Marbury, who had been appointed Justice of the Peace in the District of Columbia by President John Adams but whose commission was not subsequently delivered. Marbury petitioned the Supreme Court to force the new Secretary of State James Madison to deliver the documents. The court, with John Marshall as Chief Justice, found firstly that Madison's refusal to deliver the commission was both illegal and remediable. Nonetheless, the court stopped short of compelling Madison, by writ of mandamus, to hand over Marbury's commission, instead holding that the provision of the Judiciary Act of 1789 that enabled Marbury to bring his claim to the Supreme Court was itself unconstitutional, since it purported to extend the court's original jurisdiction beyond that which Article 3 established. The petition was therefore denied.
Background of the case.
In the presidential election of 1800, Democratic-Republican Thomas Jefferson defeated Federalist John Adams, becoming the third President of the United States. Although the election was decided on February 17, 1801, Jefferson did not take office until March 4, 1801. Until that time, outgoing President Adams and the Federalist-controlled Sixth Congress were still in power. During this lame duck session, Congress passed the Judiciary Act of 1801. This act modified the Judiciary Act of 1789 in establishing 10 new district courts, expanding the number of circuit courts from 3 to 6, and adding additional judges to each circuit, giving the President the authority to appoint federal judges and justices of the peace. The act also reduced the number of Supreme Court justices from 6 to 5, effective upon the next vacancy in the court. On March 3, just before his term was to end, Adams, in an attempt to stymie the incoming Democratic-Republican Congress and administration, appointed 16 Federalist Circuit judges and 42 Federalist justices of the peace to offices created by the Judiciary Act of 1801. These appointees, the infamous Midnight Judges, included William Marbury, a prosperous financier in Maryland. An ardent Federalist, Marbury was active in Maryland politics and a vigorous supporter of the Adams presidency. He had been appointed to the position of Justice of the Peace in the District of Columbia. The term for a Justice of the Peace was 5 years, and they were authorized to hold courts and cognizance of personal demands of the value of $20. On the following day, the appointments were approved en masse by the Senate. However, to go into effect, the commissions had to be delivered to those appointed. This task fell to John Marshall, who, even though recently appointed Chief Justice of the United States, continued as the acting Secretary of State at President Adams's personal request. While a majority of the commissions were delivered, it proved impossible for all of them to be delivered before Adams's term as president expired. As these appointments were routine in nature, Marshall assumed the new Secretary of State James Madison would see they were delivered, since they had been properly submitted and approved, and were, therefore, legally valid appointments. On March 4, 1801, Thomas Jefferson was sworn in as president. As soon as he was able, President Jefferson ordered Levi Lincoln, who was the new administration's Attorney General and acting Secretary of State until the arrival of James Madison, not to deliver the remaining appointments. Without the commissions, the appointees were unable to assume the offices and duties to which they had been appointed. In Jefferson's opinion, the undelivered commissions, not having been delivered on time, were void. The newly sworn-in Democratic-Republican 7th Congress immediately set about voiding the Judiciary Act of 1801 with their own Judiciary Act of 1802, which reversed the Act of 1801 so that the judicial branch once again operated under the dictates of the original Judiciary Act of 1789. In addition, it replaced the court's 2 annual sessions with one session to begin on the first Monday in February, and cancelled the Supreme Court term scheduled for June of that year. seeking to delay a ruling on the constitutionality of the Repeal Act until months after the new judicial system was in operation.
Status of the judicial power before Marbury.
Although the power of judicial review is sometimes said to have originated with Marbury, the concept of judicial review has ancient roots. The idea that courts could nullify statutes originated in England with Chief Justice Edward Coke's 1610 opinion in Dr. Barnum's case, 8 Co. Rep. 107a. That decision arose under a statute of Parliament enabling the London College of Physicians to levy fines against anyone who violated their rules. The college accused a doctor of practicing without a license and fined him accordingly. Coke found that their statutory powers violated common right or reason, because no person should be a judge in his own case. The U.S. Supreme Court stated Barnum's case did not set a precedent in the United States to make common law supreme over statutory law. The idea that courts could declare statutes void was defeated in England with the Glorious Revolution of 1688, when King James II was removed and the elected Parliament declared itself supreme. However, it continued to be known in the American colonies and in the bars of young states, where Coke's books were very influential. The doctrine was specifically enshrined in some state constitutions, and by 1803 it had been employed in both state and federal courts in actions dealing with state statutes, but only insofar as the statutes conflicted with the language of state constitutions. A number of legal scholars argue that the power of judicial review in the United States predated Marbury, and that Marbury was merely the first Supreme Court case to exercise a power that already existed and was acknowledged. These scholars point to statements about judicial review made in the Constitutional Convention and the state ratifying conventions, statements about judicial review in publications debating ratification, and court cases before Marbury that involved judicial review. At the Constitutional Convention in 1787, there were a number of references to judicial review. 15 delegates made statements about the power of the federal courts to review the constitutionality of laws, with all but 2 of them supporting the idea. Likewise, at the state ratifying conventions, over 24 delegates in at least 7 states indicated that under the Constitution, the federal courts would have the power to declare statutes unconstitutional. Professors Sakrishna Prakash and John Yu point out, with respect to the ratification of the Constitution, that no scholar to date has identified even one participant in the ratification fight who argued that the Constitution did not authorize judicial review of federal statutes. This silence in the face of the numerous comments on the other side is revealing. The concept of judicial review was discussed in the Federalist Papers. Alexander Hamilton asserted in Federalist No. 78 that under the Constitution, the federal courts would have not just the power, but the duty, to examine the constitutionality of statutes. The opponents to ratification, known as anti-federalists, agreed that the federal courts would have the power to declare statutes unconstitutional, but were concerned that this would give the federal courts too much power. Robert Yates argued, the Supreme Court then have a right, independent of the legislature, to give a construction to the Constitution and every part of it, and there is no power provided in this system to correct their construction or do it away. If, therefore, the legislature pass any laws, inconsistent with the sense that judges put upon the Constitution, they will declare it void. A number of courts engaged in judicial review before Marbury was decided. At the time of the Constitutional Convention, there had been cases in the state courts of at least 7 states involving judicial review of state statutes. Between the ratification of the Constitution in 1788 and the Supreme Court's decision in Marbury in 1803, judicial review was used a number of times in both state and federal courts. One scholar counted 31 cases during this period in which courts found statutes unconstitutional, concluding, the sheer number of these decisions not only belies the notion that the institution of judicial review was created by Chief Justice Marshall in Marbury, it also reflects widespread acceptance and application of the doctrine. Scholars have pointed out the Supreme Court itself already had engaged in judicial review before Marbury, although it had not struck down the statute in question because it concluded that the statute was constitutional. In Hilton v. United States, 3 U.S., 3 Dor. 171, 1796, the court upheld a federal tax on carriages against a claim that the tax violated the direct tax provision of the Constitution. Therefore, the concept of judicial review was familiar before Marbury. However, it is important to note that nothing in the text of the Constitution explicitly authorized the power of judicial review, despite persistent fears voiced by anti-federalists over the power of the new federal court system.
The issue.
There are 3 ways a case can be heard in the Supreme Court. 1. Filing directly in the Supreme Court. 2. Filing in a lower federal court, such as a district court, and appealing all the way up to the Supreme Court. 3. Filing in a state court, appealing all the way up through the state's highest courts, and then appealing to the Supreme Court on an issue of federal law. The first is an exercise of the court's original jurisdiction. The second and third are exercises of the Supreme Court's appellate jurisdiction. Because Marbury filed his petition for the writ of mandamus directly in the Supreme Court, the court needed to be able to exercise original jurisdiction over the case in order to have the power to hear it. Marbury's argument is that in the Judiciary Act of 1789, Congress granted the Supreme Court original jurisdiction over petitions for writs of mandamus. This raises several issues that the Supreme Court had to address. Does Article 3 of the Constitution create a flaw for original jurisdiction, which Congress can add to, or does it create an exhaustive list that Congress can't modify at all? If Article 3's original jurisdiction is an exhaustive list, but Congress tries to modify it anyway, who wins that conflict, Congress or the Constitution? And, more importantly, who is supposed to decide who wins? In its answer to this last question, the Supreme Court formalizes the notion of judicial review. In short, the constitutional issue on which Marbury v. Madison was decided was whether Congress could expand the original jurisdiction of the Supreme Court.
The decision.
On February 24, 1803, the court rendered a unanimous, 4-0, decision, that Marbury had the right to his commission but the court did not have the power to force Madison to deliver the commission. Chief Justice Marshall wrote the opinion of the court. Marshall presented the case as raising 3 distinct questions. Did Marbury have a right to the commission? Do the laws of the country give Marbury a legal remedy? Is asking the Supreme Court for a writ of mandamus the correct legal remedy? Marshall quickly answered the first 2 questions affirmatively. He found that the failure to deliver the commission was violative of a vested legal right. In deciding whether Marbury had a remedy, Marshall stated, "The government of the United States has been emphatically termed a government of laws, and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right." One of the key legal principles on which Marbury relies is the notion that for every violation of a vested legal right, there must be a legal remedy. Marshall next described 2 distinct types of executive actions: political actions, where the official can exercise discretion, and purely ministerial functions, where the official is legally required to do something. Marshall found that delivering the appointment to Marbury was a purely ministerial function required by law, and therefore the law provided him a remedy. A federal court has a special obligation to satisfy itself not only of its own jurisdiction, but also that of the lower courts in a cause under review. If a court does not have the power to hear a case, it will not issue dicta. Consequently, with exceptions not applicable here, a federal court must decide whether it has jurisdiction before discussing the merits of the case. Chief Justice Marshall, however, did not address jurisdictional issues until addressing the first 2 questions presented above. Because of the canon of constitutional avoidance, that is, where a statute can fairly be interpreted so as to avoid a constitutional issue, it should be so interpreted, courts generally deal with the constitutional issues only if necessary. In this case, the jurisdictional issue was a constitutional one. In analyzing the third question, Marshall divided the question further, asking if a writ of mandamus was the correct means by which to restore Marbury to his right, and if so, whether the writ Marbury sought could issue from the Supreme Court. Concluding quickly that since a writ of mandamus, by definition, was the correct judicial means to order an official of the United States, in this case, the Secretary of State, to do something required of him, in this case, deliver a commission, Marshall devotes the remainder of his inquiry at the second part of the question, whether it can issue from this court. Marshall first examined the Judiciary Act of 1789 and determined that the act purported to give the Supreme Court original jurisdiction over writs of mandamus. Marshall then looked to Article 3 of the Constitution, which defines the Supreme Court's original and appellate jurisdictions, see relevant law above. Marbury had argued that the Constitution was only intended to set a floor for original jurisdiction that Congress could add to. Marshall disagreed and held that Congress does not have the power to modify the Supreme Court's original jurisdiction. Consequently, Marshall found that the Constitution and the Judiciary Act conflict. This conflict raised the important question of what happens when an act of Congress conflicts with the Constitution. Marshall answered that acts of Congress that conflict with the Constitution are not law and the courts are bound instead to follow the Constitution, affirming the principle of judicial review. In support of this position, Marshall looked to the nature of the written Constitution. There would be no point of having a written Constitution if the courts could just ignore it. To what purpose are powers limited, and to what purpose is that limitation committed to writing, if these limits may, at any time, be passed by those intended to be restrained? Marshall also argued that the very nature of the judicial function requires courts to make this determination. Since it is a court's duty to decide cases, courts have to be able to decide what law applies to each case. Therefore, if two laws conflict with each other, a court must decide which law applies. Finally, Marshall pointed to the judge's oath requiring them to uphold the Constitution, and to the Supremacy Clause of the Constitution, which lists the Constitution before the laws of the United States. Part of the core of this reasoning is found in the following statements from the decision. In denying his request, the court held that it lacked jurisdiction because Section 13 of the Judiciary Act passed by Congress in 1789, which authorized the court to issue such a writ, was unconstitutional and thus invalid. Marbury never became a Justice of the Peace in the District of Columbia.
Criticism.
Jefferson disagreed with Marshall's reasoning in this case. Some legal scholars have questioned the legal reasoning of Marshall's opinion. They argue that Marshall selectively quoted the Judiciary Act of 1789, interpreting it to grant the Supreme Court the power to hear writs of mandamus on original jurisdiction. These scholars argue that there is little connection between the notion of original jurisdiction and the Supreme Court, and note that the Act seems to affirm the court's power to exercise only appellate jurisdiction. Furthermore, it has been argued that the Supreme Court should have been able to issue the writ on original jurisdiction based on the fact that Article 3 of the Constitution granted it the right to review on original jurisdiction all cases affecting public ministers and consuls, and that James Madison, Secretary of State at the time and defendant of the suit, should have fallen into that category of a public minister-consul. Questions have also frequently been raised about the logic of Marshall's argument for judicial review, for example by Alexander Bickel in his book The Least Dangerous Branch. Bickel argues that Marshall's argument implies an unrealistically mechanical view of jurisprudence, one which suggests that the court has an absolute duty to strike down every law it finds violative of the Constitution. Under Marshall's conception of the judicial process in Marbury, judges themselves have no independent agency and can never take into account the consequences of their actions when deciding cases. Marbury can also be criticized on grounds that it was improper for the court to consider any issues beyond jurisdiction. After concluding that the court lacked jurisdiction in the case, the further review regarding the substantive issues presented was arguably improper. Also, it has been argued that Justice Marshall should have recused himself on the grounds that he was still acting Secretary of State at the time the commissions were to be delivered and it was his brother, James Marshall, who was charged with delivering a number of the commissions. Because the Constitution lacks a clear statement authorizing the federal courts to nullify the acts of co-equal branches, Critics contend that the argument for judicial review must rely on a significant gloss on the Constitution's terms. Despite such criticisms of Marbury v. Madison, judicial review has been accepted in the American legal community.